Welcome back to another episode of the Lender Podcast. I'm Bryce Matheson, and as always, this episode is brought to you by Lender. Lender is a loan management software tool designed to help you with every aspect of your business, from origination to servicing to payoff. Lender helps you with document generation, helps you with collecting monthly payments, dispersing monthly payments to your investors, taking in new loan applications, giving your borrowers a portal that they can log into, giving your investors a portal that they can log into. Pretty much every aspect of everything that you do inside of your lending business can be done and facilitated through Lender. You can check that out by going to joinlender.com. That's LENDR, joinlender.com. Now, on to the episode.
Today, we have Mr. Kevin Kim with us, which it's not been that long since we chatted because we saw each other last week at the Paper Trail conference. So
yes,
this is a pretty good, happy reunion. Obviously, I'll let Kevin introduce himself in just a second. But first off, Kevin is a treasure trove of information. Like, if you have anything related to private lending, securities, SEC guidelines, servicing, compliance, like you name it, Kevin is the man. So this is going to be a killer discussion. I'm really, really pumped and excited to go over it.
Thanks.
So, Kevin, you bet, man. This is great. I'm really excited. And also, before you introduce yourself, one of the best part about meeting people in real life is you learn some things. So I've, lots of podcasts and things that I've listened to of Kevin's in the past. For some reason, I always thought he was like 5'1", and Kevin is not 5'1". He is a very, very tall Korean man. So if he looks short on camera,
people have told me too. I hear this a lot.
Yeah.
They're like, "Oh, you're a lot taller in person." Yeah, for the audience, I'm 6'2", and not 5'1".
Anyway, just had to throw that out there. So, Kevin, thanks for being here. Go ahead and introduce yourself, and we'll get rolling.
All right. So, yes, my name is Kevin Kim. Partner here at Fortra Law. We are the nation's largest law firm dedicated to private lending. We are kind of a full service law firm for private lenders. On the transaction side, we have my division, the corporate and securities division. We also have our banking and finance division, and we have our litigation and bankruptcy division. So on the corporate and securities side, we focus primarily in doing capital raise work. So fund formation, securities offerings, that kind of stuff for private lenders. So whether it be a simple kind of loan syndication or a fractional transaction to as complex as your, global REITs, right? So we can do all that here in-house. We also do the compliance associated with that on the security side, investment advisor, broker-dealer, Rule 144, all that fun stuff there. And then we also do licensing for private lenders. It's a very complex type of application, and so it requires a little bit of extra hand-holding. So typically a law firm is better suited to do that. So we do a lot of licensing work in all 50 states for private lenders. And then my partner, Melissa, she manages our banking and finance division. So loan documents, closing services, compliance in all 50 states for private lenders. Also, like all the other kind of transactional needs that you might have, like assignments, servicing agreements, master loan purchase agreements, all those types of transactional support. And then our litigation bankruptcy is local to California only. They specialize in kind of creditors' rights, title claims. But, the firm has been around for a long time, and we've really entrenched ourselves in private lending, private money, hard money, whatever you want to call it. And so we really love the industry and how that dynamic it is. We also have a sister company called Lightning Docs, who you guys over at the Lender are integrated with.
I was just about to mention that. Yep.
Yeah. So Lightning Docs is our national automated doc platform for private lenders. So it's not for everybody, I think. So if you're kind of small and you need someone to hold your hand through the closing and you can't close the loan yourself internally, don't recommend it. But if you are capable to close the loan yourself, nothing better than to automate your closing process, especially on documentation. I think Lightning Docs is best in class. So you definitely want to check that out if you're able to close loans yourself.
I love it. Yeah. Like Kevin just said, we just barely finished our integration with Lightning Docs, and it's very seamless. So you take a loan into the lender platform, you click a button that says kick it over to Lightning Docs. It goes through and asks you all the interview questions. And then from there you can say, yep, looks good. And then it gets vetted and trust and scanned and checked over by many, many attorneys, I'm sure. And then you're compliant and you're good to go.
Yep.
So
and shout out to you guys. You guys were like one of the faster integrations we've ever seen. So great job.
Good.
Here, right?
Good. It was actually very smooth. I just handed it off to one of our developers and it was done in like 3 days. So I was like, okay, cool. Sounds good. We're connected now. So with that, actually, I have a question right off the bat. So most people, especially those that listen to our podcast, are small mom and pop local private lenders, and they typically lend in their own backyard.
Yeah.
One thing that we get a ton of questions about is like, can I lend in Colorado? Can I lend in Arizona? Can I lend in this state? You know, so I've listened to one of your other podcasts, and you briefly went over and you mentioned like, okay, most of these states back east, you're usually good to go, but like everything on the West Coast, California, Colorado, like, can you go over just like basic high level, like what can you do? What can you not do? What states should you be careful with?
Let's kind of level set on what the loan type is, because this thing changes a lot. So in private lending, the most common residential loans, so 1 to 4 family, right? That's the key, I guess, collateral type. And the loan is business purpose, non-owner occupied, and the borrower is an entity. This is the most common fact pattern that we see in private lending, right? So if that's the fact pattern, you need a license to make that loan or broker originate that loan in California, Arizona, Nevada, Oregon, Idaho, Utah. Now, there's a little bit nuance in Idaho, right? And then you also need a license in Minnesota, the Dakotas, and Vermont. You can navigate the exemption most likely in Florida. The lender has to be an accredited investor. And then North Carolina has a slight bonding requirement. It's not a license. It's just like a small registration of the state. These are the states that require a license for that kind of loan. But let's say, for example, that fact pattern changed. Let's say in that fact pattern, the borrower were an individual, right? Not an entity. Well, that changes the fact pattern, right? And then we need to deal with other states, for example, Washington, for example, Virginia, for example, Florida. Let's say the property's owner occupied, right? By its business purpose. That changes the philosophy too, right? So it depends. But most of the time, 90% of the time, the clients we're dealing with in residential, it's that non-owner occupied, business purpose, entity borrower situation. And so those are the states that require it. Now, these states all have wholesale exclusions, and most of them do, right? So like, in California, for example, if the arranging broker is a licensed real estate broker, he brokers that loan to me, an unlicensed person, I can rely on his license to both be exempt from licensing, but also be exempt from usury because it's been arranged by a licensed broker. And many states are like that. So California's like that. Oregon's like that. Idaho's like that. Arizona's like that. Nevada's not like that. So Nevada's tricky, right? So Nevada's a little bit trickier. Minnesota's a little bit tricky. Not quite crystal clear in Minnesota either. So it's a very nuanced issue. For the small lender, what I always advise is if you know for a fact what markets you're in, right? Historical records it is what it is. You can't unring that bell, but get compliant because, you also have to think about if you don't have a license, are there other ancillary issues? Primarily like in California, like our licensing regime is tied to our usury. So like if you're not licensed and you made a loan, okay, sure, there's like de minimis exclusions and, the state's not going to, invalidate your loan. What the bigger problem is actually only licensed lenders, brokers or lenders are exempt from usury in California, and usury is at 10%. So California is one of those states where like, I don't like it when people mess around, and it's so easy to just bring a broker on, right? And so same with Oregon, same with Idaho. You can just bring on a lender to help you, right, and be compliant and pay them a small fee and be able to sleep at night, right? And the small shops, you have a lot more to lose than the bigger shops do, right? So
for sure,
yeah. So in my opinion, it's something that's easy to comply with. The licenses are kind of hard to get. I get it, right? But it's worth all the headache coming out later.
So 2 questions here. So first, let's say I'm a private lender. I have no idea what I'm doing. I don't know what my licensing requirements are in my given state. Say I want to reach out to Fortra Law or to you directly. What's the best path to do that? And
easiest way is our website. Yeah. fortralaw.com, or just email me, k.kim@fortralaw.com. Our number's on the internet. Like you can find us pretty easily. So
okay. And just rough price range, like what does that cost if someone's curious?
Licensing, I mean, it ranges, right? So depending on the number of licenses you get, right? So generally speaking, you're looking at about anywhere between $6,500 per license for most states. That's a promo for the lender audience. Or, roughly speaking, California is the one weird one. It's $8,500 to do California because California is famous for being like hard to get. It's just hard to get it, right? So the California finance lender's license, average turn time is like 12 months now. And it's purely a byproduct of just government inefficiency. Like they just don't know what they're doing anymore. Unfortunately, the budget got cut. They don't have enough examiners. The NMLS transitions. So a lot of stuff happened past 5 years since COVID that they just got really inefficient. Other states are a lot easier. So like you'll be done in and out in Oregon in a few months, but there's a lot of prereqs. So I don't like it when people just like kind of jump the gun and go for it. Like you kind of have to get the prereqs done first. So usually what the best path forward is to give us a call, right? For licensing inquiries on my team, you want to talk to Jennifer Young. She's the partner in charge of, helps me run the division, but also she's in charge of our licensing desk. So she's the lady who knows everything there is to know about licensing for private lenders.
Got it. Yeah. Okay. Now let's say I'm a private lender, and I see this all the time. Is you kind of like, you started dabbling, you did one loan here, you did another loan there. Let's say now all of a sudden all this information comes to light, and I'm like, oh shit, I need to get licensed.
Yeah.
Like what? So let's say I did an oopsie and I didn't know. A, if I do get caught, what happens? But B, retroactively, is there anything special that you need to do?
Well, in the small lender circumstance, the first thing we do is we look for the de minimis exemption at the state level, right? Every state's a little bit different in how they approach this, right? So the most hardcore state in the country is actually Nevada, right? California is similar, but California has a de minimis exemption, right? So it's one every 12 months. And it depends also, like if California off the top of my head is the worst one, right? Because the concern that I have is that loan, the risk that the lender has, if they have no licensing involved, which is very rare in California, but if it happens, the risk is really a usury risk. And so it's not a licensing risk. It's, the state's not going to step in and invalidate the loan because you didn't have a license. Well, now the borrower has an argument of usury, right? And so now you've got this, basically this issue that the loan could get invalidated. So, hope to God that loan pays off, right? So,
yes,
that's going to be cross your fingers or figure out how to modify with a licensed broker. But, that's your kind of concern there. California is weird in that respect. Most of the states that have usury restrictions don't have this kind of restriction. So in those situations, you just kind of, is what it is. If you've fallen outside the de minimis exemption, hopefully, we can set up a new company and you can move on, or, you just kind of, you can't unring the bell, but also you kind of let sleeping dogs lie and you move on. Most of the states are pretty understanding. Like even in the worst case where it's just licensing, lack of licensing, the state will, send you an examination order and they'll say, hey, go get licensed, right? They're not going to say like, they might penalize you, right? And that's kind of the worst of it. It's not like you have like, oh, you're banned from lending or we're going to invalidate that loan. They can't do that because it's an arm's length negotiated commercial transaction. It would be bad public policy to invalidate the loan.
How often do you see those types of circumstances or cases where the state does come back and be like, uh-oh, you did not do this the right way? Is it like, do you think that every day, or is it try
to invalidate a loan? The only time I've seen a state come in is like, you're not licensed, give us an answer. And then we say, oh yeah, our bad. Like we don't have an out, right? Like,
well, not specifically on the loan, but just like as far as licensing, like how often does somebody get caught?
That happens a lot, right? Because it doesn't come out like that. Like very rarely. The only time I've seen it is in Nevada, right? So the state they're just like a hawk, right? Because it's just a small state. They keep the eyes on the recordings, and they'll know right away. And it's a small
public record. That makes sense.
Small population state, right? So they keep an eye on it. I think they've got a dinger set up. The second they see it, they ping you. And what they do is they say, hey, get licensed, right? Like, get licensed. And they might throw you a small penalty. The penalties stack, obviously, the more times you do it, right?
Sure.
The more often where I see it is where the lender is applying for a license and the state does a basic search, right? And they can find, oh, you've been lending, huh? What's the story here? And so that's where it's important to do. This is where it's important because a lot of times there's an answer to that story, right? but the client doesn't remember, right? So we always tell the client, like, this is why it's so important that in private lending, especially, not to use like, there are a lot of like turnkey vendors for like conventional mortgage licensing, and they're not going to be able to solve the problems that come up. There's a lot of problems in these licenses. So, that's where it pays to have an attorney kind of step in and help. The nice part is even California, they're not interested in raining hellfire down on someone like that. They'll pick their targets to make an example out of, but like typically if you don't have an out, like if you have no out and you have no workaround, then you just kind of own up to it, and the state will just say, listen, you screwed up, here's a penalty, and then our job is to negotiate the penalty down, and then we want you to get a license, and that license application will take a long time, right? It is because now you done messed up, right?
Yes.
But at the
messed
same
up,
time,
Aaron.
there are workarounds, right? And that's the clients stress out about it. Like, listen, here are the solutions to get the deals done, even though you don't have the license just yet. And it usually involves getting a third-party licensee involved. So,
got it. Okay.
there are like unique carve-outs, like like Arizona. Arizona is interesting because like for 1 to 4 family, you need a license no matter what you do, right? Or you get wholesale too by a licensed broker or lender. Right. But what's interesting is for a multifamily, so 5+ multifamily in Arizona or any commercial real estate over $250,000, you don't need a license. As long as you lend it on still on balance sheet, you don't need a license for that.
Oh, very interesting. I didn't know that.
Very unique, yeah. They view that as institutional, but the key prerequisite is that you have to lend off your own balance sheet. You cannot like wholesale this out to somebody else.
Got it. Okay. So you also briefly touched on usury, which I think most people are familiar with usury, but I see a lot of things where people will like, do a really low interest rate, like 10%, but then they'll jack up the points and do like 4, 5, 6 points to get past that. Like, talk about that. How does that work?
This is actually like nationally the way usury is calculated. Like I can't say every state, but if the research per state, but generally, right? Generally, big picture, you have to annualize in the fees, right? So the way we advise on usury is if the state has a usury cap, you have to assume that the state is going to annualize in the fees to a loan, right? So 10% rate, 10 points, you got to think of it as 20. You can't think of it as 10. And there are states that have caps like kind of on the higher end in the teens. Like Texas has a 18 cap and a 28 cap, depending on the transaction style, right? And so, that's why you don't see anyone you do hear about it, but you shouldn't, right? But the nice part is most of the country for commercial transactions, I would say more than half of the country for commercial transactions don't actually have a usury cap. So it's less concerning, right? And so, but it is important. It's state level, and it's definitely not something you want to get cute with. Because like my advice in general, in all things in lending, if you get cute with the rules and do something that acts as a workaround to the rules, the state is very unlikely to take that and let you do it, right? Like there has to be actual statutory support for it, right? And so, doing that kind of stuff is not advisable.
Which I think is probably just a great rule of thumb anyway, right? Like there's rules and regulations in place for a reason. Like do it the right way.
Also, why are you charging so much? Like it doesn't make any sense. Like,
I wish I could say I charge that much. I'd have to know.
First lien, if you're doing a first position bridge loan on a house and you're charging 20%, like what are we doing here? Like, come on.
Yeah, it's crazy. I agree. Let's talk about servicing, because this was something that we brought up this past week when we were chatting, and I actually didn't realize this myself personally, that you do have to be licensed to service, but there's some caveats there. So talk about like how most people do it and what that all entails versus servicing other people's deals.
Yeah. So this is where the idea of third party servicing is really important, right? And so if you service loans for others, that's where the licensing activity comes in, right? If you service your own loans, I made a loan off my LLC and I own the loan and I'm contacting the borrower and collecting payments, no issue, right? No state in the country is going to say you need a license to service that loan for business purpose, right?
Right.
Consumer's a whole different ball of wax. But when it comes to this phenomena of like, oh, I'm going to like, this is a very common kind of thread from the conference we were together at, but in general, I'm going to originate a loan, I'm going to fractionalize it, and then I'm going to retain the servicing. Well, you just became a loan servicer because those other co-lenders of yours are third parties. And in some states, like my home state of California, the definition of third party is very, very, very broad. And so the state has went so far, like I think it was one case where like the ex-wife was considered to be a third party, right?
Oh, interesting.
A girlfriend living in the same house was considered to be a third party, right? So and affiliate entities still considered to be a third party, right? They're not the same entity, right? So, and not every state's like that, obviously. And not every state requires a license for servicing in business purpose residential. So that analysis is important too. But you have to ask yourself, if I'm gonna arrange that fractional deal or do a participation, right, or whatever it is, right? You have to ask yourself, does this trigger licensing concerns from a compliance standpoint? And when it does, it's you're servicing on behalf of another lender, right, including another fractional lender that you're co-lending on with, right? Participation's probably not because it's not a loan technically, right? This comes up also for the shops that will either sell paper or correspond. So they'll fund a loan, they'll sell it to the secondary market, right? And they're able to retain the servicing rights. Okay, well that loan just left your books. You're no longer the owner of record on that loan. Does your state require licensing? So that's the key analysis you have to take. And it lines up similarly with the states that require a license for lending, but the licenses are different sometimes. Like, so I keep going back to California. California, we have two licensing regimes, but for third party servicing, it's the Department of Real Estate license that you need, which is a lot harder of a license to obtain because it's an individual license first. So, that's the kind of complication that comes up.
So I see a lot of people, especially a lot of listeners to the podcast who will, easy numbers. They'll say $100,000 loan. I'm going to put in 20,000. I'm going to get 30,000 and 50,000 from two other people. So under that does require licensing for service.
Oh, for sure. Right. Because if they're
even if it's on your books.
Well, okay, so that's the nuance that statement, right? So if they do fractional, meaning that the other investors on the loan are listed on the promissory note and deed of trust or mortgage as your co-lender. So you've got like three different lenders, a fractional interest, pro rata, whatever.
Yeah.
Well, that's a third party, right? So and you're servicing their loan, their portion of the loan. So that does require a license in states like California. Now, if it was I own the loan and you, Bryce, have a participation interest in that loan, that's different, right? Because I'm not servicing your loan anymore. I'm servicing my loan. I'm paying you, right? So it's different, right? So what was good, what was nice about like the paper trail, I was expecting a lot of folks to still be truly fractionalizing. It seems that a lot of folks have kind of come around to the ideas of participation agreements and hypothecations and so on and so forth. So those are good things, right? Those are structures to get around the issue of like, well, I'm not servicing for another party anymore, right? And also, like, it's just more efficient because now you own the asset and you got a derivative investment from it, right? So,
right,
it's cleaner. But yeah, I mean, it's always an issue when you do third party. That's the key issue. Yeah.
I like the distinction there because it's my personal opinion that you should not put the co-lenders on the deed of trust. I know why they would want to be because, but from like a liability and litigation standpoint, like assume you go into foreclosure, like all of those people, correct me if I'm wrong, are like all of those co-lenders are going to get pulled into court and will have to testify.
Well, if they're listed on the promissory note, that's the most important agreement, right? So the prom note is really the loan agreement or promissory note, whatever you use, right? That's if they're listed there, right, as a lender. The deed of trust is just the collateral instrument, right? So the most important document is actually the promissory note. If they're listed there, yeah, and that's just one of the things. Like I tried it myself, I didn't like it, right? So like co-lending in general, my kind of preferences, this is my opinion, is like if I'm listed as a lender of record alongside, let's say, four other lenders, well, if something goes sideways, I'm getting sued. Like I'm getting sued. Right? I don't like that, right? So, I'd rather have the lender get sued, and then I'll deal with the losses or costs or expenses, but let the lender get sued, right? So,
absolutely,
yeah.
Agreed. Okay. So a couple things here that I want to touch on. We can kind of pivot and move into like funds and securities because I think there's a lot of overlap here. But one thing that I do see a lot of people do is they will set up a fund, but then they will also have other investors who either A, are not accredited and don't qualify, or do not want to be in the fund. And so they're like, I'm just going to make a promissory note between me and you, and that way you'll personally guarantee my funds.
No,
is that kosher? Is that not kosher? What's your opinion?
I mean, it can be kosher. The issue you run into is like, where do those other investments land, right? So there's a lot of different variations to that fact pattern. So you got your fund, separate LLC or separate LP, and then you got your, fund manager co, which is usually where the principal sits, right? So let's talk about the example of the non-accredited investor. Okay, typically the solution is either the non-accredited investor will make a debt-based investment to the fund manager, right, as an alternative investment, or they'll in turn do a trustee or co-lender situation. Well, so first thing you have to ask yourself, well, that's an investment. You have to analyze securities laws, right? A one-off whole loan, right? Maybe not a concern, but if you do it frequently enough, it's not viewed as a whole, and you're doing this in series, right? So it may not be compliant. And the way the federal securities regs work in this circumstance is if you're offering securities like that, as an actual means of an offering, then you may have to have offering documents you will have to have offering documents if the investors are not accredited. The law mandates it. So one of the things to make sure that people understand is if you sell a security to a non-accredited investor, the law says anti-fraud laws require you to deliver the equivalent of a prospectus, right? Which is a BPM. Yeah. So like the idea of like, oh, I'm just going to do stuff on the side with these non-accredited guys. Like, it's a little risky. If it were like you're selling a whole loan to them, right, in an isolated transaction, that might be compliant. But if you do it in on a frequent basis where it can be viewed as an offering at large, well, there you might have a concern, right? Now, the other fact pattern you mentioned, right? Oh, the debt instrument, right? It's like the management company will take a debt instrument. That might be okay, right? So the issue there is like, does the fund documents disclose the fact that the manager is also separately raising money? Is the fund manager offering that note as kind of a workaround to deploy the capital into the fund? Because then it's kind of like, what are you doing, right?
Yeah.
The commission might be like, well, especially if that counterparty is not accredited, right? Like, what are you doing here, right? So, it's a nuanced issue, but I would say the best practice in most circumstances where you have affiliate offerings, you've got a fund, you've got other offerings of investments going on. Best practice is to disclose the fact that affiliate offerings do exist and may exist, and then also make sure that when you're doing those offerings, they're compliant, right? So like this comes up a lot when a client has 3 funds, right? Well,
right.
Do your fund documents disclose the actual specific identity of those 3 the activities, identities of those affiliates? They should. And then when it comes to like the fact that you're dealing with non-accredited, I mean, I just tell clients in general, like, absent the whole loan brokerage scenario, there's not a lot of carve-outs for non-accredited investors. Like very, very few without offering documents, right? Like very, very few. So, and that should show you that because the government cares about them a lot, and so they're going to regulate you to be compliant. So
and protect those.
Yeah.
Well, and the reason that I bring all this up is because as we onboard people onto the software platform and tool, I don't offer consulting, or we don't offer consulting, but people will just ask generally, like, what do you do? Like, how do you structure this? And so we've shared like, well, this is what we've done in the past, whatever. But it's just, I get a lot of these same questions. Like, I want to do a fund, but I also want to capture those non-accredited people. And so I want to set up a 506B, and then I'm going to set up a 506C. And I'm like,
that could work. It might, it might not work, right? There's that integration rule, right? So like, it depends. Are they identical offerings? Then no, right? But if there are different offerings, like actually different offerings and different entities and, that kind of stuff, then you can, right? I don't advocate doing 2. Like, it's like, to me, it's like, why would you want to burden yourself of having operating 2? Just operate the B and ask yourself, like, okay, do I really need the non-accredited? I do. Okay, that's fine. Do the
I
B.
really need to solicit? Yeah.
And then, well, no, the answer is you can market, you just can't market the fund. You market the business, right? And you can market the fund, the business, not the fund, right? So B prohibits general solicitation and advertising of the fund, but you can market the business all you want. I'm a lender. I'm doing these deals. I'm doing those deals. That will garner enough attention from investors anyway, right? And the second fascinating part about 506B is that, like, you can stop the offering, close the offering, wait 30 days, open a new offering, and get 35 new slots. So it's like, okay, well, this is not the old rule, right? So the old rule is 90 days. So the new rule is 30 days. So it's like, well, that's not terrible, So I would prefer it where the client be honest about what they need. And then after maybe the second iteration of that, you should be thinking about Reg A as opposed to running serial Bs, because it's just, you're going to hit a place where you might need to start marketing the fund. And so for those kind of sponsors, an A is the best option because you need the non-accredited investors, but you should be ready to invest, right? Because it's a big lift. So, like, that's not the common pathway. The common pathway is to concentrate on the accrediteds, because,
and I was going to say,
you need
most
capital anyway. So
I would assume, I don't know, but I would assume very few people go the Reg A because of all the compliance, and it probably doesn't really fit like the private lender-ish model as well as like
it's used. I mean, there's a handful of shops that have really made it work. It's just it's a higher resource drag, right? They're more expensive to run, right? They're legal and not constant in all the reporting. You are fully, regulated, right? It's a fully public offering, so know that, and the reporting, right? So, and if you mess up, you have to shut the offering down until you get it renewed, right? So, but if you have the infrastructure for it, you can do it. But I don't advocate for it for most. I think that most people are better served by starting with a B. Get that friends and family money in. The buddies that you have from high school and college who may not be accredited, and then move to a C. Because that's what the vast majority of people. And honestly, the accredited investor community is a much less burdensome capital raising community than dealing with non-accredited investors. It's not worth the headache.
Absolutely. Yeah. Absolutely. If you had to like boil a lot of your experience and like just everything that you see on the day to day, like what would you say are some of the biggest security law issues that you see with private lenders and that they typically overlook?
So I kind of break it up into different sectors, right? So the market is so big now, right? It used to just kind of be one, you kind of had two layers, right? You had the middle market and then you had the institutional. Now you have this dynamic kind of lower middle market, and then you have the upper middle market of like the big debt funds, right? And then you have the institutional market, because the entry level market has actually become very dynamic, and there's some concerning aspects to how dynamic it is, right? And you see a lot of interesting strategies that are being used, and so that I won't comment on or advocate, but like the big picture on the kind of the middle market is really still the basic, like are you selling securities to non-accredited investors without offering documents? Are you having the basic level of understanding of like what you are offering it's a security? I still get that a lot, right? So
I bet
the very, very simple concept of like, LLC interests are securities, loans are securities when the counterparty is an investor, like those kind of basic level things. Where things get complicated upstream is actually not so much on those basic level compliance items. It's actually more portfolio activities triggering additional compliance issues. So like, for example, like debt funds buying and selling securities in their portfolios. Those that causes a lot of additional compliance, or debt funds now going into the crowdfunding universe and becoming a Reg A. That creates a lot more friction, right, on the compliance. And so that's kind of the upper middle market, and at the institutional level they have their own other issues, but I don't want to waste your time on that one.
Sure. So expound on that first one a little bit. You said a debt fund purchasing securities. I assumed that the Regulation D exemption, that was kind of the whole point. So elaborate a little bit.
Clarifying point. Yeah. So Regulation D has to do with the offer and sale of your own securities, right? So issuance, right? So I am creating a company. I am selling securities that I control. I am the issuer of the security. I am selling those securities, right? I am the sponsor. But the nuance is that fund doing things in its portfolio that constitute the purchase and sale of security, meaning that in its business plan, right? So this is a good example. We had a debt fund that went out and bought a bunch of CMBS and RMBS and like real estate related public securities in their portfolio, but they didn't have all of their investment advisor compliance and investment company act compliance in place. That led to a lot of regulatory oversight and enforcement actions because they did that, right? Because now you're a hedge fund, right? You're basically acting like a hedge fund. Hedge funds are regulated differently than your average kind of mortgage pool fund structure or real estate fund structure, because your average debt fund in private lending, they only just have have loans. They don't have anything else. Maybe a money market account for cash drag, right? Yeah. Like that's all they do, right? They don't, and they're all their loans. It's not like they're buying other loans from other people. And even if you're buying loans, it's not much of a. So like, you don't have any securities selling going on, buying or selling in the portfolio. You don't have a brokerage account, right?
Got it.
In the fund.
I see. Okay. That makes more sense. Yeah. Okay. Because that was going to be my next question, because we see people all the time who, they raised a bunch of money. They don't have enough deal flow to deploy all that capital. Yeah. And so they will buy other people's loans or debt off of their balance sheet in the meantime. That's okay.
Yeah, I mean, once again, right? So it's a nuance for loan purchasing. On the family resemblance test, the Reeves test, we don't want to trigger those issues. The nice part is it's lender to lender sale, right? And it's an actual purchase agreement, right? And there's actual due diligence being done and underwriting being done by the buyer and all that kind of stuff. You've got hopefully fulsome reps and warranties in the purchase agreement. Those types of box checks will result in the argument that it's not a security, right? But let's say, for example, I'm a debt fund and I sell a loan to someone like me, Kevin Kim, right? I got a day job. I'm looking at it as an investment. I'm relying on you. I'm not going to do the underwrite. I'm like, okay, 6 LTV in California, 12% rate, looks good to me. Let's do it, right? That's the sale of a security. So you'll be very nuanced in that context, right? So like, how are you buying it and who are you selling it to, right? Or who are you buying it from, right? All those issues. So I tell clients in most lender to lender sales, right? Even then, to make sure you cover your bases, you kind of want to mimic what the institutions do, right? You want to have that purchase and sale agreement alongside the assignment and a launch, right? Because ordinarily, when Fannie and Freddie buys loans from a mortgage banker, you enter into this lengthy contract called a master loan purchase agreement, and it has all these reps and warranties and covenants in it. I'm not saying you need that. I'm saying you need something, right, to make it make the transaction appear to be an asset sale, right? So that you can't question whether it's an investment or not, right? So it's an asset sale. So that's what makes it good. A lot of times, what happens is at the upper middle market is like they just do assignment and launches on the loans, but that then you as the buyer or you as the seller have no covenant protection, no rep and warranty protection. So how do you know who you're selling to is the right person, is the correct person to sign? Those basic level things on top of all those additional reps and warranties that you ordinarily see in these purchase agreements. So I tell clients when these small debt funds buy and sell amongst, they're usually buying like tapes of loans. Have a basic purchase agreement drawn up. It's not that expensive,
Interesting.
Nowadays, we have them on the shelf because we deal with them all the time with the institutions.
Right. Absolutely. Tell me, so I think for whatever reason, the definition of a security is at least among private lenders, is so convoluted. Nobody understands what a security is. By definition, what is a security?
That's the problem, right?
Okay.
That's the problem, right? So a security is really just any time you sell a investment opportunity, right? And so it's very vague on purpose. And so there's two operative tests. There's the Reeves test, which governs notes. And then there's the Howey test, which governs everything, right? And you have to kind of use them both. ultimately, and I've seen assets that you would never believe, like leaseholds, be deemed a security, right? In this case law, that a lease was deemed to be a security. So yeah, because they were fractionalizing leasehold interests in commercial real estate, right? So it doesn't matter necessarily on what it is you're selling. What matters is the kind of expectations around the parties and the reliance on the seller of the security and the necessary reps and warranties or lack of. And so those are kind of important. So ultimately, how I tell people is, if the relationship in which you're entering into the sale is that you are raising money, right? Whether or not you're raising money for liquidity or to fund a new deal or to whatever the reason is, you're raising money. You should question whether securities laws apply or not, right? Second thing is, who is the counterparty? Like, who are you dealing with? Are you dealing with a high net worth investor, or are you dealing with, I don't know, a bank, right? Like,
Got it.
If you're dealing with a bank, the likelihood is it's probably not, especially on the loan side of the transactions world, right? So, like, let's use the example of selling a loan, right? If I'm selling a loan to a bank, it probably won't be deemed to be a security because there's going to be all the necessary agreements. The bank is going to do their own credit underwriting. And in reality, they're not relying on me. They were looking at paper, right? And so they're not an investor by any means. They're just buying an asset. But if that lender sold that loan to me, Kevin Kim, I got a day job, 50 hours a week. I got 2 kids. I don't have time to be a lender. I'm not a lender, right? I'm looking at the rate. I'm looking at the LTV. I'm like, all right, looks good. Let's do it, right? I'm looking at it as an investment. Right?
So is it more of the like, trust me, bro, I got you? Like, you're relying on somebody else's due diligence?
Yeah. I mean,
is that it?
If that's the thesis behind, if that's the relationship between the parties, it's definitely a security, right? Now, where I get a lot of funny questions on this stuff is like, I get a lot of folks trying to nuance this, and they say like, well, what if we make it an active investment? I'll move over to LLCs, right? So like, this is a very common ask in the LLC, especially in real estate. We're like, oh, we're going to go in on a house. I'm going to raise some money on this house, but they're going to be active, right? I'm like, okay, what does active mean to you? Well, they're going to be members of my LLC. Well, no, first of all, like, equity in an LLC is de facto a security, right? The stocks and bonds, right? So the issue you have to deal with is like, are they actually active? And there is a carve out. Like, if they're active partners with you in the traditional sense of being a partner, then that is not a security, right? If you and I were to partner on a business together and we are both actively involved in the business, right? Like, you're ordering inventory and I'm dealing with accounting and we're both dealing with vendors and we're going out there and getting customers and all that. That's active, right? Versus I'm going to sit there, earn a payment, and I'll vote on selling the property, right? That's not enough, that's still pretty passive, right? So you have to answer that question. And so if it's truly an act, and so this is where, like, in real estate, JVs are very popular right now. JVs are fine usually because there's active involvement on the cap table and the operations of the acquisition project. And so even if they're a capital partner, right? So they're actively involved. And so very rarely does that create a securities issue. But if you look at the way the operating agreement is written, like, they're participating in monthly meetings, they're approving budgets, they're approving vendor requests, they're approving expenses over a certain amount. They're approving renderings and site plans, and they're doing all this stuff, right? And that's important to be considered active. In that circumstance, that's not a security. Right. But in your average JV that I see, it's where it's just like, I'm going to bring the money, you're going to do all the work, I'm going to make 25%. That's security. The nice part is it's a small security, right? It's not that hard to deal with the compliance. So,
okay. Yeah. So I want to make this like crystal clear, because again, we talk to a lot of lenders and a lot of people will say, well, I'm doing whole note investing, so it's not really a security because I'm just brokering the deal, versus I'm doing fractionalized where I do carve up the note and put the different investors and do it that way. This is security. This is not a security for the context of private lending. Who should be worried? Who should be licensed? Who should be regulated? What exemptions? Like, all of that.
So I do want to dispel the myth on the whole loan side. Okay, so even if you're brokering the loan, right? If the counterparty who's funding the loan or buying the loan is someone like Kevin Kim, day job, not doing a full underwrite, that trust me, bro. I'm trusting the originator. I'm relying on his expertise. I'm relying on his experience. That fact pattern, it's deemed to be a security. However, almost every state in the country has what's called a whole loan exemption. So it's exempt at the state level. And because it's one loan, that one loan is the one security being sold. And so we don't have to overanalyze. Look at where the investor lives. What does the state say? Whole loan exemption, we're covered, right? Now, that becomes more complicated and fractional and all these other shit. I don't want to get that deep in the weeds on that. But like the nature of the transaction is what dictates whether it's a security or not. That's important to people. Like they should understand, whole loan, you are selling a security, even if you're brokering the loan, but you're likely exempt from registration because the state does not require that transaction to be registered, right? This is how you see a lot of folks do those one-off kind of note instrument investments too, right? They'll just do a company level loan, right? If I see like 1 or 2 a year, maybe 5 a year from random people, I'm not going to be as concerned, right? A company can take 5 loans, whatever, fine. But if they're doing this like, 10, 15, 20 people, and they're all non-accredited, and they're promoting this thing, yeah, you're going to get a call from the regulator, right? We had this problem on the East Coast. Thankfully, it turned out they were all accredited, but like we weren't sure. The client wasn't sure because they're like, oh, I was just borrowing money from my friends and family. Like, well then, but you were promoting the investment opportunity. So like, that's that doesn't jive, right?
Yeah.
So, and even if it is friends and family, like how many of these are you doing a year, right? So does it look like an offering to you, or is it kind of a one-off loan transaction from a buddy? And then even in those circumstances, like, is it a real loan transaction or is it more of an investment? You should ask yourself that question, right? Because, and be honest with yourself. If it's an investment, just own up to it, right? And it is what it is. Most likely, I can give you comfort that it's going to be okay because there's a whole loan transaction exemption at your state.
Yeah,
the investor lives. But you shouldn't hang your hat on that, because if you do 20 of those things, even without marketing, because I would still probably think about compliance, because the way that's going to be viewed is that you're offering, you have an offering of an investment opportunity, right? They're programmatically being offered. That's what I call it, right? And you should think about complying in that circumstance.
So for those people who are listening and they're like, okay, I'm definitely doing more than 5 of these per year, but I'm also not doing 100 per year. I'm kind of in this like small time, like I see it as like
the answer. Yeah.
What is like, because it feels insurmountable. It's like, oh, I have to go set up a fund and I have to get a fund manager. But and I agree, that's not the case. But like that's the word on the street. That's whether misconception or not. That's what people think you have.
It's kind of my fault too, right? I promote funds. So, and I'm a big biased believer in the fund strategy for private lenders, but it doesn't have to be that way.
Yeah. So very like the next natural step for people who are like, well, I need to do this big time.
My philosophy has always been do what's right for your business, right? And so while you may think that I'm the big fun guy, I also do a lot of note offerings. What I tell the client is we should formalize this. We should formalize the offering. If you're doing this to people, doing this a couple times a year, and it's like 5 or 6 people, and they're all kind of within your immediate family or immediate close friends, and it's very few numbers, and you're tiny, I probably wouldn't say much. But where I get nervous is that, okay, tell me more about the transactions. Okay, they're all kind of 12-month loans. They're all 10%, and they're all non-accredited investors. I get really nervous when that happens. They're all the same kind of loan, right? It's like if a regulator looks at that, they're going to say, well, you're offering an investment, right? So let's get compliant, right? So the first thing I tell people, listen, you're going to have to bite the bullet on being compliant. It just is what it is. So some folks will choose, all right, I'm just going to deal with accrediteds only, right? Because honestly, they haven't adjusted it for inflation. So it's like,
it's really not that crazy.
It's not that crazy. It used to be really crazy, but now it's like, 15 years, 20 years later, like that, they haven't adjusted the net worth or income test. So it's like, okay, whatever, right? So
yeah,
I always tell clients, like, it's not as burdensome as you think, and it's going to save you a lot of heartburn. And so if you're going to do a small scale offering to all accrediteds, I usually say no outward marketing, right? Or sub 20-ish investors and everyone's accredited. I'm not going to mandate like full fund documents. You're going to do what I did with a lot of sponsors, like one of our mutual friends, Devon, right? Like we just did, accredited investor representations, securities filings, and you're covered, right? Because it's a small scale offering.
Yes.
But if you're going to be doing this larger, I want to go out there and do this, do this, right? Actually offer this to more than just my immediate network and do a true friends and family raise, go out to different circles and, and start raising, whether or not you advertise or not. And you know what, you want to exceed the 20. I would probably think about formalizing and having offering documents just to protect you. But it can still be a debt instrument, right? Like you can still offer debt instruments. And that might not, it might not be the time for you, right? And making the right fit is important. And you may choose to say like, well, I'm going to take the risk on it and do no offering documents, but just do the bare bones kind of requirements. And, I'm just going to risk it because I can't afford it. Okay, that's fine. It's your choice to make, right? It's ultimately my rule. My rule has always been like, client has a business. It's his risk, not mine, right? Ultimately, we have to make it fit for him. So we have a lot of clients that just do, simple investor note with an accredited investor representation, no PPM, basic securities filings, and just do that.
I love it. I love it.
See, not so advisable at scale, but it's totally fine at a smaller level.
Well, and that's what I love is because, like I said, it feels insurmountable because people don't realize that you can even do that. People are like, okay, I'm doing direct placement, like assignment of notes, or I have the fund, and there's no in between. But you're saying there is an in between, and
there's a lot of solutions. The big linchpin is the accredited versus non-accredited to me, right? It's like outside of the whole loan circumstance, which is not very common, right? Most folks do fractional. You're playing with fire because you're dealing with the fact that the mom and pop investors who the SEC and the state regulators care about, you should not be selling them securities without offering documents. You shouldn't, right? So if you're comfortable sticking to the accredited investors, the world of options opens up, right? And you can do it on a low budget. Now, I don't advocate that at scale. I never advocate it at scale. So if you tell me that I want to scale this thing, well, then we need a full, But that's a different mindset. Now you have entrepreneurialism. You should be investing in your company. Do it right. Do it the way everybody else who's going to become your competitor is
doing it. Yep.
Yeah, because you don't want to be coming to the dance with shorts on. That's kind of how I look at it.
I love it. I love it. Oh, Kevin, like I said, you are a treasure trove of information. And I think all these questions are like things that private lenders have all had in the back of their mind. They're like, I don't know if I'm or if I'm compliant. I don't know if I'm doing this right, but I also don't want to spend a fortune. And I love the different, options. I love it.
What I run into more often than not is they tell themselves they need the non-accrediteds. And I always, it's a couple of years later, like, oh yeah, you were right. It's not that bad. Like the obsession of needing the non-accredited, it makes no sense to me because of this no adjustment for inflation. Two, they're so hard to work with because it's not their fault. It's really like we need at least about most lenders will need at least a minimum investment of $20,000-ish, right?
Yep,
it's a lot of money to a non-accredited investor.
Agreed.
And it's stressful for them. So it's like, why create more stress for yourself? Like. The accredited they're 20,000 ain't going to do anything to them. They're going to be fine.
Yeah. Yeah. We have, for example, one investor who's like, they've got over $500,000 with it. I think they're up to like $700,000 with this. I literally never hear it from them. Like I send them a monthly statement and they get their interest and that's all they care about. So
someone like me, like I have not even a lot, like 50 with a client and I don't bother him because I know what's going on, right? It's fine.
It's good.
It happens. And just before your eye, I am not liquid enough to invest anymore. So
everybody, if you're listening to this, reach out to Kevin. He's got money to drop in your.
I was liquid enough, and now I bought a new house, 2 kids in private school. New way,
and you live in California, so
and I get
taxes out of the yin yang.
Half goes to the government. So.
Yeah, I love it. Kevin, I want to be very conscious of your time. We're just about an hour here, so I'll let you go. But just wrapping up, is there anything that you'd like to say? Anything that you want to get off your chest, or just in general that you'd like to say to the audience?
Well, your audience is what I love about your audience is that they're the new market entries, the smaller shops, and I love it, right? Because the I always want to tell them, don't be intimidated by, the guys upstream, right? Don't be intimidated. Those guys are not as, it's, you guys are all the core of the industry, and even the big funds out there, they started doing what you're doing. So there is a very big mountain to climb, but it is very doable. The market needs more independent private lenders, and so, best of luck. And if you guys need anything, just give us a holler. We love to do kind of a smaller market, new market entries, and advise them, because one of the best things about my job is I help clients go from day one to several hundred million under management or several hundred million in origination, and I have countless stories of that, and that's kind of part of the reason why I've been here for so long. So
I love it. Well, and I would also say basically, like you said, it's not a zero-sum game. I mean, there are plenty of people out there who do just want to get to 10, 15 million, and they're okay with that because it's a lifestyle business.
100%.
They don't want to have this gigantic $300 million fund. I would say that's very atypical, at least for the people who listen to our show. So I think that's very encouraging.
And there's so many ways. The beautiful part about private lending is there's so many ways to be successful in this industry, and there's so many ways to fund your business and strategize and outsource, and there's ways to do it that doesn't require a giant team, right? We were talking about this when we were together. I was like, I have a client in the Valley in Scottsdale, they've got a tiny little team. They don't do more than loans than they want, and they kind of just live their fun lifestyle. They got 20 investors. They play golf together. They're playing golf more than they are working, right? And that's fine too, But they do good deals, right? And they do the deals that they want. And so there's so many different ways to run these businesses, and there's no right way or wrong way as long as it's compliant. So
right, I love it. Kevin, thank you so much for your time. Once again, do me a favor and strut your socials or your phone number, email. What's the best way to get in contact with either you or your team?
We're on all platforms. So we're big on LinkedIn, Fortra Law, right? I'm on LinkedIn. You can come find me. Website, fortralaw.com. My email, all of it, right? So we're very much online. So we're on Instagram, we're on LinkedIn. I don't think we're on TikTok, so but
you're not missing much there. I can guarantee. Yeah,
it's easy to find us. The name is, if you can remember the name, Fortra Law. I think we're the only law firm called Fortra Law, so you can find us pretty easily there. And honestly, LinkedIn is a really good way to reach me. I'm on it all the time. Also email k.kim@fortralaw.com. Really easy way to reach us. Our website has a direct kind of contact Kevin link on there. So if you can't remember the email address, just go to the website.
Perfect. I love it. Kevin, thanks again. Appreciate you being here. And until next time, we'll catch you next week on the Lender Podcast.